Okay, so we're entering now. We're starting to see here some of the attendees. Yeah, I'm seeing here that some of the attendees are already here in our webinar. Let's just wait 1 or 2 minutes because I think they are entering at this moment, so we can start our webinar. I'm actually going to start sharing also the presentation, the part of the beginning. Yeah, we have a lot of attendees getting here now. Just please tell me if you can see. Yeah. So can you see the presentation? Just waiting like 1 more minute and we can start. I think we can start here. So hello, hello everybody. Hello, and people all over the world that are watching our webinar, called Ship Set Sail to Discover Tech Transfer Practice at Universities Around the World. We are here, the four of us. My name is André Sarmento. I work at Chip Global IP, and we are also here with 3 renowned professionals in the tech transfer area. I think we can start even our webinar by presenting them, since our attendees are arriving still. We already have a lot of people, but I think we can notice from this side that a lot of people are arriving now. So I think we can start this webinar by presenting to you our speakers. I would like to start for José Carlos. José Carlos is the person, that speaker, that will start our webinar. José Carlos is a professor on intellectual property rights from the State University of Rio de Janeiro, and a senior partner at the same time in Vaz e Dias Advogados e Associados. So he's based in Rio de Janeiro in Brazil. Holding a law degree by the Universidade de Brasília, a PhD degree in law, and a LLM degree by the University of Kent at Canterbury, England. José Carlos Vaz e Dias is an attorney at law specialized on patent, trademark matters, and foreign investment law since 1993. His activities are focused on legal support and consulting to foreign companies that want to invest in Brazil, especially in the technology fields. He works on trademark prosecution, patent and trademark litigation, and various matters related to foreign exchange, control laws, technology transfer, and the taxation matters applicable to the inflow of technology and investments. Regarding Waziu, who's going to be our second speaker, as you can see here, he's an intellectual property specialist at the University of Cape Town in South Africa. Afo has a technical background in chemistry with bachelor's degree in honors by the University of Lorin. I don't know if my accent is the most correct one. University of Lorin in Nigeria. A master's degree and a PhD degree in natural products and synthetic organic chemistry by the Cape Peninsula University of Technology. He complements his skills with advanced certificate courses in IP and an MBA in strategy. Afo has vast experience in developing IP strategy, IP management, and commercialization of chemistry inventions, as well as biotech, advanced materials, and life science inventions. Afo's previous work with the venture capital industry focused on the art of venture funding, business incubation, and acceleration of scaling for IP-enabled technology-based business with good market fit. Then, last but not least, we will have Faye Kasibawi, who, as you can see here once again, is a knowledge transfer manager at Royal Holloway, University of London. Faye Kasibawi is a senior technology transfer professional with solid IP management, commercialization, and business development expertise. Faye holds a bachelor degree in technology and a master's in biological sciences research with honors by the University of Auckland in New Zealand. Faye has more than 10 years of experience in the field of technology commercialization out of academia, with track record in cybersecurity, life sciences, and civil engineering. Faye started her career in Proteomics Limited. Once again, I'm not 100% sure if my accent is correct here. A spin-out of the University of Auckland in New Zealand. Taking a part in running a preclinical trial, it exposed her to the innovation life cycle, Following that, she moved to GE Healthcare, where she worked as an account manager, supplying researchers from government institutes to university and small pharma startups with research solutions. Interacting with researchers at that level opened her eyes at the value of research output, and she wanted to be able to deliver that value back to the society. Hence, in 2010, she joined the Auckland University of Technology, AUT, as a technology development manager. Since then, she worked in City University of London, and currently she is a knowledge and technology transfer manager at the Royal Holloway University of London. These are very interesting profiles that we have here today. These three profiles are very interesting. I'm very impressed. I think we're going to learn a lot from the three of them today. I'm very interested in hearing what you have to say to us. But before that, I just want to thank all the attendees that are here with us today. I think that we are all happy and impressed due to the fact that we had hundreds of people registering for this webinar out of more than, I would say, I think it's 26, 28 countries. The last time I checked, all over the world, we have people in Asia, Europe, Africa, America, all the continents. And I would like to also thanks particularly to the people that are attending this webinar in the countries of our speakers. So in the UK, in Brazil, and South Africa, that I think that they are a bit, the number of attendees in these countries is even a bit higher, probably due to the fact that we have our speakers being from there. So thank you all. I hope you enjoy all the knowledge that it will be shared today. So we will begin with José Carlos, then it will be Wazil, and we will finish our presentation with Faye. It's important to tell you also that there's the possibility of you making questions to our speakers here during our webinar. You just have to go here on the top to the option of chat, and you can leave us some questions that will be asked and answered at the end of the webinar. Thank you very much. José Carlos, I think I will pass you the control now, so you can start with your presentation.
Okay, yeah.
José Carlos, sorry, let me just.
Yeah,
okay, I think you're controlling now.
That, yeah, okay. Okay, hold on a minute. Yeah, okay, right. André, I think I'm having difficulty to move around the let's see here, hold on. Yeah. Okay. Oh, hold on. I can't. Yeah. Oh, yes. Hold on. Yes. Okay. André, thank you very much for commenting about my academic career. Also, what I really work on a daily basis. You know, I am an attorney. You know, so I am the senior partner of intellectual property and innovation law firm in Brazil. And also I am a professor of the Faculty of Law of the State University of Rio de Janeiro. And in that university, I also render, as I am a professor, free services on legal to the technology transfer center of the university. And it's a pleasure for me to be here, to be invited by Ship Global to talk a little bit about Brazil. And the objective here is to show to you, the improvements of the legal environment for research and development, in the Brazilian territory. And I have chosen a specific title that's Break the Fortress of the Roman Empire Influence, because after the sixth slide, I'm going to talk a little bit about ownership, right? And when you talk about Roman Empire and the influence that it had in the continental countries in Europe, and also in the past that it was a colony, of Portugal. Brazil was largely influenced by the Roman, and also the civil law. When you talk about property, it's something really like sacred for us. But at the same time, you have a incompatibility between property and research and development, because most of the research developments, especially those that are run in Brazil, they are usually private and public companies and public research institutes, and when they go together to develop something, they usually set their own pace, and their own percentage of property for the possible research development, that they reach, at the end of the research and development program. So I'm going to speak a little bit about it. And for me to speak, let's see if I can, okay. So that's a disclaimer. That's very important, that everything I say here, it's on my own risk, it hasn't got anything to do with the firm and also with the university. And for me to speak about the improvement of the legal environment for technology transfer is important for me to speak about the past, because from the 1975 through end of the 90s, Brazil was transferring technology to Brazil was a huge problem. Why? Because very little technology was produced, in Brazil, and most of the technology was imported. So due to the importance of this imported technology, the Brazilian government interfered largely on the inflow of technology. So one of the restrictions was the need for the technology transfer. I'm talking about licensing, patents, know-how, and also technical assistance, was the recordation at the Brazilian Patent and Trademark Office. And the examiners of the Brazilian Patent and Trademark Office in the past, they really entered into the agreement, and they checked exactly if the technology was very important to a company, and not only to a company, but you had to evidence the past, the impact, the positive impact of that imported technology, into the Brazilian market, into the Brazilian economy. So another point that was really a problem, was that know-how was not considered as a proper licensing subject matter for technology transfer. So according to the legislation, and also according to the Brazilian Trademark Office, when you license technology, talking about know-how, license know-how, when you talk about know-how, you see that's technology that's not patented or not patentable. So it was not accepted. So once you transferred it, once you evidence it to the Brazilian company, it's the licensee, the Brazilian, the imported or the licensor could not request the return of the technology, because as the know-how is not patented, it's like also you transfer the technology and you cannot return. So there were loads of restrictions, and those restrictions, they were within two stages. First of all, they were legal, was really written rules, and that prevented the parties to negotiate really. And the second part was the understanding of the Brazilian Patent Trademark Office. And those understandings, they were not written, but they were understanding of each examiner. So that made really difficult for you to transfer technology into Brazil. So due to this state interference, so little room was left for the parties to negotiate. The parties, when they were about to execute and negotiate, they were very much worried, not about the impact of each of the terms, on its business, So licensee, was a Brazilian licensee, was very much worried about what the Brazilian government would say. So it was extremely difficult because everything was restricted. So the general concept of developing, in a sense, importing technology was a kind of win-lose concept. And it was a kind of discrimination against the foreign companies or foreign licensors, because they always think, well, if the licensor, if the foreign one is transferring, is licensing technology, it means that they are not trustworthy. So in the past, it was something like that. You know, it was really difficult to make business in Brazil when you talked about technology transfer. One very important statement here that I said before, and I'm restating now, is that very little technology was produced in Brazil. And when you say during the 70s, 80s, and 90s, you know, it was during the time where the closed innovation was prevailing. And then after the 90s, you know, in Brazil, we had, you know, the influence of the open innovation. And the open innovation permitted, you know, the connections between research research centers, public research centers, companies, foreign companies, for gathering and developing jointly technology. So that was a big improvement. And then you had a landmark in Brazil that it was the innovation law. And the innovation law, when you say about the innovation law, is that we have a law that rules the development, that rules the innovation in Brazil, but it doesn't mean that Brazil does not import or has decreased the importation of technology. In fact, when the research in technology, when the innovation law takes place, you know, like during the 2004, you know, a greater amount of important technology was adopted because, as I said, no one, you know, Brazil or Argentina or any other country in Latin America or even in Europe, you know, it has all the technology. So part of it has to be developed and part of it has to be imported. So the great matter or the great advantage or good aspect of the innovation law was about the promotion of partnering. So now we have the public research centers. Why I speak a lot about the public research centers? Because during the 60s, 70s, 80s, and 90s, the Brazilian government invested a lot on sending researchers overseas. So a great amount of PhDs, the technical fields, went to the developed countries, you know, and they returned afterwards. There was a grant for 6-7 years. Then they returned and they went to the public universities. So you have the companies that they have the money, they have huge Brazilian companies, and then you have the technology that are at universities. So what they did, the innovation law, they promoted the strategic alliances. And that was really nice. So for example, the State University of Rio de Janeiro, where I teach, you know, and where, you know, I see loads of partnerships between that university, state universities and companies, you know, it's really nice, you know, that you see the developments and also the increase of patents, you know, not patents by the university, but patents coming from those strategic alliances. So you have the innovation law, you know, in all the universities in Brazil, you know, they run, you know, into those partnerships. So also, of course, the promotion of partnerships, they also went through, or they were complemented by stimulating the universities to support innovation. So the universities are free, you know, contrary to the past, you know, the universities and also the companies, they are free to negotiate. So the state no longer interferes in the developments or the research and developments agreements. And also the importation of technology now is much more flexible than in the past. The trademark office, the patent trademark office, still needs to register or to record technology and transfer agreements, but there is a matter, you know, it does not go into the business. So now the parties, like foreign and local companies, and even for the innovation for the R&D, you know, the parties now may negotiate. And one important point, of course, is the incentive for companies to promote innovation. It means lots of investments and also like fiscal benefits, fiscal deductibilities, and etc. So now with innovation law, which is considered a landmark, we have a change of the mentality. Now let's be practical, let's make money, and talk less about what the government thinks. For the companies, when they go into a partnership, like especially including foreign companies too, now they are, they are really welcome into the Brazilian market. When they go with universities and also with local companies for the developments of new technologies, now they are very much focused on the business and on making money. So with the flexibility of the law, we had an increase of research and developments partnerships. Also, if you consider the past and nowadays, the amount of patents developed by universities, public and private, and coming from those R&D centers are stunning. Like a huge amount of patents. The only problem, maybe, that sometimes they do not, the patents do not go overseas, is because the innovation law, like any commercial agreement or any business depends on financing, and sometimes going overseas, patenting several countries, is really expensive. But the most important point is a new mentality for business. So first of all, that I like very, very much, foreigners are welcome. If they pass, they would not trustworthy. Now they want to do business. So if you want a company like a Procter & Gamble company, not a subsidiary in Brazil, but a really American company, they want to do business here in Brazil into R&D agreements and also license technology to Brazilian companies. They most of the bureaucracy changed, and also the mentality changed. Now they have the freedom to contract, and this is really nice. Once again, focus on your business. For the local universities and for the local companies, the mentality changed. If in the past Brazil was considered the country, because we were very nationalist. Now Brazil is one of the several markets of interest, for the foreigners, and also the interest for the Brazilian companies and universities. That's why, it's really interesting to see the local companies and also the universities patenting and also registering their trademarks overseas. This is really nice, a new mentality. And one of the aspects that changed a lot with the innovation law, especially in R&D agreements, are the matter concerned property or ownership. According to the civil laws, the civil code of Brazil, the best stage or the best scenario is I have one property, it's mine. When you have a partnership or when you have a co-ownership, it's awkward because you have one subject matter with several owners. So when you have several owners, sometimes the one owner may be hampered or may be prevented to license or to explore in a different market. So co-ownership was always a huge matters, especially for the development of technology. But with innovation law, what the innovation law did? Just said, well, you settle the parties. Now you settle the ownership. For example, a Brazilian company, such as, for example, Petrobras, it's a public company, may be the owner of 100% of the ownership of a developed, technology with such as a Texaco. But the Texaco may be, Petrobras has 100, but Texaco may be the party that will exploit the technology, or maybe a split of 50-50, or so each party, when they go into research and development, they may settle, the terms of exploitation. And that, that change in the law was really good. So one of the cases that I participated was in the British Gas case. That was back in 2014. You know, and the British Gas that had a peculiarity in Brazil. First of all, for the exploitation of oil and gas, for the exploitation of telecommunications, for the exploitation of energy in Brazil, all the companies, they have to invest a certain amount of money into research and development. It's compulsory. So, for example, talking about the British Gas, they had to invest 1% of the gross revenue in high production, and they had this task of investing and also negotiating with the companies. Some companies also negotiating with public universities, but they did not want to be the owners. For them, is we wanted to go into research and development, develop the technology. But what we really need to do with this technology is to use within the group. So I am the British Gas. I have a subsidiary in the US, maybe in the state of Texas. So I want my subsidiary to use. So, but ownership, I'm not interested. So that was quite stunning. I said, wow, you know, like a company that doesn't want to be the owner. No, so the innovation law was really nice to accommodate this new way of dealing with ownership. So, like for the British Gas, they also executed agreements with universities like the Federal University of Rio de Janeiro, and the Federal University was the owner, you know, and the Federal University could license the technology, you know, that was developed, you know, through the partnership between British Gas and the university, but it was guaranteed for the British Gas to exploit it within its subsidiary. So it was really good. That's why I said that was a rupture, or was a break of the Roman Empire fortress, because for the Roman Empire, property was the most. You know, for them to be the owner of something was sacred. So in Brazil, with the innovation law, that changed a lot. You know, so what you have here, no ownership, but the freedom to use internally. No taxation rules and procedure. So when I go for the drafting R&D agreement, also I have to look at the taxation laws that deals, you know, also with the property. You know, that in a sense, who invests in technology, for example, such as the British Gas, in a sense, has to hold the administration of this technology, this developed technology, by any means, even by paying the annuities and supporting, you know, the patents in one country, Brazil, and in others. You know, like universities. If for them, it's important to have the property. There's no problem at all. You negotiate with the company, with your partner in the R&D development, and then you do whatever you can do, establish, you know, that the property belongs to the university or not. And sometimes the university, you know, can have 100%, but is the company who exploit the technology into the Brazilian market, and exploiting the technology to the Brazilian market. You know, although it's the university has 100% of property, but it owns only 1% of the revenues. It's possible. The innovation law has made it flexible. So for business, this is excellent. You know, so what you have here, flexibility of property, is not a problem here. Let's make business. You know, let's stick about the discussion about the civil code. Yeah, you know what you have to do. You have to state and establish specific rules on intellectual property, on exploitation of results, and you know, and according to the business, you know, and also establish the property matching the business model, and also not only the business model of the parties, but also the fiscal laws. So this development, like a new mentality, freedom to contract, you know, permitting especially the universities that in the past was really difficult. When you develop, you would go into a partnership with State University of Rio de Janeiro, with a company, and at the end of 5-6 years, they would develop the technology. That was a state-owned technology. Now with the innovation law, no, we parties are gonna split up, not necessarily 50-50, not necessarily 100% belong to the university or the company, but we are gonna set the deals, according to our business, and of course, following up an agenda of negotiations and of the business method, in model that the parties want to adopt, and what's the practical result? Now you have an amount of research and development agreement is increased a lot, so maybe in the past, because, when you go into R&D agreements, maybe at the end you do not reach what you wanted, but yes, maybe in great extent, you may reach what you wanted. You have a technological product, and then we are expecting in the near future, obtaining more results and also more patents. So the change was win-win solution. There's not a win-lose solution. I am university, you are company. I am Brazilian company, you are foreign company. So let's make a deal. So it's a win-win solution. No state interference. So what I want to do is to do business. So this is I would say that the basement for the developments of technology, in Brazil. So my university uses this basement, or this structure, the freedom of structure, for developing technology and also for going partnership. The most important point is doing business. Let's make deals, and then for the universities, deals are excellent, and also for the companies, as the universities, they have most of the knowledge, and for them it's developing new technology, there is a risk, of course, but it has decreased a lot. So property rights are no longer sacred. Check your interest in leverage, and that's the business. Going for partnership. That's what I need to say. Okay, Andrea, it's with you.
I think you have the control now, so you can start your presentation.
Perfect. Yeah, I have the control now. Can you hear me, Andre? Yes. Okay. Absolutely. No, thanks, Andre, for the introduction earlier, and thanks, Jose, for the lead in on the legal aspect of intellectual property and how the landscape is changing in Brazil. Ekuroleo, my folks from Nigeria, and Sawubona to colleagues and participants from South Africa. Welcome to all participants that are able to join us for this webinar. I'm Wasiu Afolabi, and currently I'm the intellectual property specialist at the University of Cape Town. In the past few years, I've mainly been involved in developing IP strategies for SMMEs and early stage businesses. Oftentimes, I also get involved in strategy development for corporate and small businesses, but majority of my time I work with higher education institutions on matters relating to intellectual property and technology commercialization. So in this session, we'll probably just have a brief look at what technology transfer has been in South Africa and what is the state and the gaps that are very visible, which are the main pain points at the moment. And also, as we do that, I would also use a few case studies relating to how we run technology transfer at University of Cape Town, how we're able to leverage our resources to achieve some level of commercial success for our technologies, and yeah, also the main gaps that we have at the moment and what we're doing, to reduce those challenges. Essentially, in South Africa, currently there are about 37 publicly funded R&D institutions. And yeah, this is very most important to note that funding for research and development in South Africa mostly comes from, corporate industries, but heavily, most of the R&D is done based on public funds. And if you're funded by public fund, you're meant to be governed by the IPR Act, which is just the equivalent of the Bayh-Dole Act in the United States that govern how you incentivize the inventors and also the ownerships, how benefits are being shared, and also what happens in terms of exchange control, regulatory approvals, etc. Just a snap, this comes from a survey that was done over 4 years that was released by the National Intellectual Property Management Office a few years ago. And that just shows what the dynamics is. Currently in the landscape, we have only about 169 practitioners that are servicing this 37 high institutions. And there's still a skill gap in terms of headcount as to those that are pushing technology transfer in South Africa. And also the main pain point also at this point is you have about 78% of the institutions, they do not have sufficient funding to commercialize. So getting the funding for early stage R&D is one thing. When you have the product, that are ready for the market to commercialize them is also huge. But the government is trying its best. Substantial amount is being invested in R&D and also in the management of tech transfer operations in South Africa. How is this management what is the overall landscape or look or feel of IP management in South Africa? What the survey actually then also showed was every tech transfer office or every institutional science council deemed it necessary. Like it's very important for us to manage this IP so that funders, taxpayers' money doesn't just go to waste. However, what you can see, what we realize is the capacity or capability to engage in most of these activities is actually lacking. Only few of the practitioners or officers are able to engage in infringement litigation or infringement monitoring. Most of what we do is on, receiving invention disclosures. We're very good at novelty searches and also managing IP registration, etc. So on the administration and IP management side, we're heavy. But on the enforcement side, that's where we leverage IP firms, IP attorneys, whether locally or externally as well. For the commercialization, which is later downstream in when you've had the output, you will say there is a significant drop in terms of the capacity of the respective higher education institutions to commercialize or even do heavy lifting for commercialization activities. While yes, everyone deemed it important, like yes, we need to commercialize the output, we need to engage in technology commercialization activities. The capacity or capability to do that is still, very much lacking. And what you then see is if most of them doesn't go through licensing, most of the IPR Act still, end up not really going through the optimal route or landing up in the market, and still forms like a kind of a deficit. But most institutions, what they've then been doing essentially is, to outsource most of these tasks, whether locally or internationally. But when it comes to, the marketing, negotiations, setting out, spin out companies, quite a few industries are getting involved and, able to do that. So it's still like a call, continuous call. It could even be participants in this call, or you have folks within your networks. If you really are in that space where you have specialist skills in fundraising, mentoring, and support, you're able to lead spin out companies. South Africa is actually on the hunt. It's actually a fertile ground for such skill set, because it's highly needed. I would just implore you to get in touch with tech transfer offices or those that are doing active R&D in the space. But one thing you just need to bear in mind is when it comes to statutory compliance, South Africa is very heavy, and most of the institutions are very heavy in that. They make sure they comply with the necessary act on regulations. They're able to do the referral, so you'll be in good hand when it comes to that. But when it comes to other aspects of tech transfer activities, fundraising, leading companies, negotiations, those are areas that that could really be of major benefit, and it's still really lacking. In fact, it's a critical skills with any country at the moment. Looking inwards at the University of Cape Town, over the past few years, UCT have just come to devise, a new method, or should I say, a new process wherein we're able to better commercialize our inventions, and rather than the usual means of just trying to license whether locally or exclusively overseas, we developed in specialist skills, to also license and develop regional hubs or the knowledge economy within the country. And we use often we use the technology cluster model, wherein we look at specific units within faculties or within department, and we group the research effort. For example, when we're looking at renewable energy fuels or catalysis, we try to see the different multidisciplinary researchers and inventors and see how their products or inventions fit together, and then we commercialize that as a basket. Instead of a one-to-one or a linear process, we're seeing more value in, how do we look at the different units and, commercialize their product as a whole. Also, we're seeing that a lot in the biotech and the pharma research and medical sciences, wherein you might have the specialist skills, in do the in silico model, the upstream design, development of, the possible targets. Then there will be another faculty that is highly skilled in, expression of the enzymes or inhibitors. The manufacturing could be, a gap that is missing, that would be outsourced, from another faculty. So yeah, making this into a whole basket and, putting in all our effort into that has really been yielding really good success. And yeah, in terms of our processes at UCT, generally we're quite flexible. And the one certain aspect of our process is we implement stage gate mechanisms, for maturing, whether it's the IP of technical development or commercialization. And if the outputs it doesn't meet a certain score, you wouldn't necessarily be allowed to go on. So we try to be lean in terms of how we deploy funds and how we also use our time, the resources available, and also the human capital. How do we then commercialize? Is there a pathway? Do we do straight licensing, or do we prefer to spin out? I will say we don't have a preferred commercialization pathway, and also even at the early stage of tech development, maybe at TRLs 1 to 3 or 4, we don't really have a defined path for commercialization up until when we've assessed the risk, the cost, the resources, industrial partnerships, government interest, etc. So these are factors that we then bring into the fold before we then know which commercialization process we should undertake, and oftentimes also rely heavily on the feedback from the inventors themselves. And just like any company, so we run the tech transfer office like a mini business itself, like a mini business venture itself, when we do our own in-house research, we do our own market analysis, we do our own business plan, business process engineering, etc. And what we do is constant reiteration. We utilize feedback loops to then find alternative pathways in our decision making. Though we're the leading institution and we serve as role model to most other institutions, we are also constantly redeveloping our process. But the gaps, just like any institution from this hemisphere, is doing critical market analysis, marketing, industry collaboration, forming spin-out. Oftentimes we rely on outsourcing most of this work, and also much more recently we developing sort of incubation processes and internships for postdocs and PhD students, such that we can bring them in, teach them more about a little bit about IP and also entrepreneurship. So we're trying to not only just churn out technology output, but also we're building our expertise around entrepreneurship, around market analysis, and those that are super complex, we outsource to collaborators or other entities or ventures to assist us. So this provides like a snip of our process in terms of the stop or go, no go that we do follow. One thing to just note is for any technology, whether it will go through the licensing route or whether it will go through the spin-out creation, our IP strategy always goes with the commercialization strategy and also with the technology development timeline. That has to go hand in hand. One doesn't lag behind the other. So up until you've disclosed to us, we've checked if it complies with the IPR Act. Then you can go on. So we've done our freedom to operate, and we actually exploit the IP. That's when we then do full assessment of invention disclosure, do prior art search, and then we work actively, start engaging with the inventors to help to mature the technology and also to start developing a business case for it. Each of these go, no go, it involves external experts that we bring from outside UCT. It involves our office, the Tech Transfer Office. It also involves, an oversight. At UCT, we have the Intellectual Property Advisory Committee. We have the PAG. So we have different oversight groups that helps, monitor the budget, monitor the IP rights, monitor, the equity we take, the licensing right, the agreement, such that everything just goes hand in hand. And in instances where we have implemented this model and processes in a lean way, we've actually been able to, make some really good commercial successes. So at UCT, just looking at a case study, which might actually be applicable to most universities as well. Normally, internally, you have a portfolio of patents, know-how, lab scale experiments that you can do, and you have talent pool. Those are valuable, to the external companies. But oftentimes we use the one-to-one or, one-to-many. What we've done is trying to map out platform of platforms. For example, the Biofarming Research Unit. These guys express pharmaceutically relevant recombinant proteins in plant and insect cells. And we've seen that they hold the largest portfolio of molecular biotechnology inventions, even in South Africa. So in that case, we have that in-house skill. So data was built into a specialized unit, that is then serving multiple platforms. An example was the spin-out Cape Biofarms. So the R&D that couldn't be done within UCT are then being done, in an industrial environment. When it comes to the manufacture and market access, they then spin that out into Cape Biologics. Much more recently as well, we looked at our marine biotech portfolio. That was a straight one-on-one, technology absorption, into a spin-out company, wherein the researcher was directly, then sent into the company to help, further develop the company as well. So this then shows, active effort that the tech commercialization will only be done if you then go closer to the faculties and also try to map out what are the specialist skills and what will be the best routes to commercializing those inventions. And this could be applicable to infectious diseases, diagnostics, biofarming, energy, renewable energy, chemicals, catalysts, etc. And lastly, we do active industrial engagement. Just to round up, there is a lot of involvement with regional knowledge hubs. We don't work in silos. And also we organize catalyst launches where we bring industrial partners to engage with our researchers, just to get the conversation going. IP protection barriers, what exactly are we doing? Yes, researchers has the freedom to do to conduct the research they want at UCT, but we create awareness, on innovative projects that could be done, just to ensure that innovative and purposeful research is still being done towards some market need. tech transfer tools, we constantly try to scout alternatives, try to be on par with global best practices. We also maximize what we have. Early stage commercialization funding fits into the next point, which is at UCT now we've tried to have different pots of funding from pre-seed to innovation builder to evergreen that will further de-risk our project even before we take it before external funders. And patent maintenance cost is a nightmare for every commercialization agent or every technology transfer office. But we try to build, we only pursue quality patents. And lastly, this is a must for every tech transfer office, is to make sure you get objective fact-based portfolio reviews. What is the quality of your portfolio? And to do that, oftentimes we outsource globally using experts in the field to help us review those portfolios. And our tech transfer processes is continuously being optimized. 2020 was our inflection point. We had to hire more good heads to help look into marketing, into new venture support, into other aspects of coordinating our project. But in this year, 2021, now we're trying to form synergies, external partnerships, global best practices, positioning the office, to be run more effectively. And other offices, if you're trying to be optimal, you're trying to commercialize more, you have to evolve year on year. And lastly, you have to look for external support from government, from elsewhere. So largely, we engage more with the National Department of Science and Innovation, leverage the IPS support fund, technology support fund, whether locally or internationally as well. So this just gives like a brief into what we do at UCT. And so I hope just in this few contexts, you'll be able to learn a thing or two about tech transfer landscape in South Africa and what we do at UCT, and what we're doing in terms of to improve our IP management processes and effort to commercialize, and how you can get involved, where we are and where we think we should be and where we're going. Looking forward to engage with you. Feel free to reach out to me if you have further questions. And on this note, I think, you can take over, Andre. Thanks.
Thank you very much, Wazio. Faye, you have the control now, so I think you can start with your presentation. Give me just 1 minute. I will put the presentation again, and I think you just have to enter twice, and then if you give me just 1 second.
So do I have the control now? Yep. Okay. Okay. Thanks, Andre, and for organizing this. Thanks, everyone. Thanks to the audience. And I'm gonna, in the interest of time, I'm just gonna try to be brief. And a lot of what I'm gonna cover here already being discussed in Waso's presentation. So the practice of technology transfer is about capturing the value and protecting that value and turn it into product and services that generate public or social and economic impact. This is the focus of what we do. Of course, we deal in a university, we deal with different types of innovation, but typically there are two types. Innovation that targets a specific, well-defined problem, and this is the case in the pharma and drug development, of course, and cybersecurity. And the other type of innovation, this is disruptive kind of innovation, where technology generated to create new markets. In a typical commercialization pipeline of a university, we deal with a mix of IP, all the way from algorithm, software to biological and chemical material. Now, it's really important to create a process for commercialization that can be applied to all this different type of IP. Okay, it can, in order to capture the inventiveness and protect the inventiveness, and of course, turn it into product and services. It's very important to create this process and share it with the academics or the inventors in order to create a transparent and collaborative working community, because we do believe in this. It has to be a positive engagement and a partnership with the academics. So in order to generate the trust in our processes, initially, the first thing we have to formulate a transparent and easy to transfer process. So going to the process. Developing a process of commercialization is based on different factors. I tried to summarize it here by focusing on the policy, the commercialization and IP ownership policy that is usually unique to different universities. In the case of Royal Holloway, or generally the IP and commercialization policy defines who owns the IP and who has the right to commercialize the IP. There is usually different stakeholders. There is the academic, the student, and the postgraduate students. So initially we have to define in different kind of intellectual properties who owns what. And then comes the resources, and this is something also we saw touched on earlier, is the capacity, the people capacity that we have, and the available funding for outsourcing the different specialties that we don't have in-house. And then we look at the different strategies based on the kind of technology and the target market and the potential challenges that we might meet in that market or in taking this technology to the market. And then putting all this together will support us in forming an easy to apply process that is transparent and transparent to the inventors and can be applied consistency among myself and my colleagues. So in this slide, I tried to summarize how Royal Holloway IP ownership policy is basically summarized. As I mentioned earlier, we do collaborate with different entities. We do collaborate with different, or in-house, we have different people or different levels of individuals involved in generating different type of IP. So the main thing is to try to summarize the policy in a clear way. Who owns what type of IP? Now, the strategy that we put in place consider different factors. We look at risk, the type of technology that we're working with, whether it is a technology that's coming out of market pull or technology push. We look at the immediate resources and the potential market we're going to. Typically, at Royal Holloway, we commercialize through partnership and the license agreement. Okay, and this is something we usually practice in a case of a market pull, where we have a very clear innovation or very clear solution to an existing problem. We do this a lot with our School of Biological Sciences, where we develop the basis of a lot of Duchenne muscular dystrophy treatment through a very positive partnership with Sarepta. The other type, of course, of innovation that I touched on earlier is about technology push, where there is disruptive new technology coming. And in this kind of technology commercialization, we encourage the academics to take lead on that, especially that this is something there is the passion behind it, there is the belief in the technology, and of course it is risky because it's a new area, but the best thing is to get the academics to lead in the commercialization of their invention. We offer them the training, the full-on training, and we have different governmental programs to achieve that. For example, we have the Cyber ASAP program, where it takes the academic through serious levels of training to lead their own commercialization. Going back to licensing strategy, we of course operate through different kind of license agreement. The one that is commonly used at the first stage is the evaluation license. A lot of companies do that. We like to do that because it is low risk for both parties. One thing we are moving away from as a university is exclusive license. The reason for that is because most of our research is publicly funded. We are obliged to ensure that the outcome of publicly funded money, or the IP that coming from publicly funded research, is not used to give one entity any competitive advantage. In fact, the main focus of this is that we ensure that this IP is applied for the benefit of the society. So definitely moving away from, especially for the kind of technologies that can be developed with in different ways, or using or go to different niches, market niches, we going more towards something called semi-exclusivity, which is very applicable in a pharma area, especially when we're talking about different types of, or we're talking about DNA sequence that can be applied into different vectors or different plasmids. So we recognize the best thing for us as a university is to offer more semi-exclusive license than an exclusive license. So coming into the commercialization pipeline, in my view, the commercialization pipeline is a combination of the technology transfer pipeline and the innovation cycle or the technology transfer process. Why? Because I do believe that they both need to be aligned and transparent, and there is a need for this pipeline to be shared and understood between the lab and the office. So as long as the process is aligned and transparent, both partners can work in synergy together to take ideas from the lab to the market. And also it supports us to identify and discuss the potential risk, potential bottlenecks, and work towards mitigating potential risk in both pipelines. So considering, of course, going back to this partnership, we recognize the need to formulate or create common language in both pipelines that is understood between the academic and of course, the technology transfer office. So in terms of the technology development, it's best to be mapped against a common or an understood pipeline with a common language between both parties. The commercialization or the technology pathway, which is part of the commercialization pathway, is a sequence of events, is very common to what other universities or research institutes have. It comes with different points, checking points where we initially, the first one is about defining the application, defining the value proposition, who could benefit from this value, what is the market space look like. And for us as a university, the IP plan or the IP management process is a part of the business plan. We also touched earlier on the cost, the maintenance piece, and that's for us going forwards with a patent application is always a business decision, because unless there's a proven value proposition, there's a proven market for this technology, we don't go ahead and initiate the filing for the protection unless there's a proven market and proven partnership in the pipeline. So in summary, our role is to ensure that the publicly funded research generate value that goes back to the society, whether it is economic or social. And as well as that, I wanted to emphasize the technology transfer process has to be defined in order to be shared with the academics, and in order for it to be consistent. It has to be defined, practiced, and consistent. Thank you.
Thank you so much to José Carlos, Waziu, and Faye for your presentations. I think they were very interesting. We already have some questions for you. I think it's the most important thing to do. I'm sorry everyone, because it's a bit later than what we expected, but I didn't want to interrupt, of course, anyone, because I think everybody found very interesting what you all said. So I had two slides prepared to speak about what we do actually in SHIP. But I think as it's more interesting to hear now the questions and answers that you have to give us, I would like to tell you that I will send our presentation at the end of the webinar that we just did. And that in SHIP we work with three types of clients: the corporate ones, the law firms, and the universities. All of you three are here today in this webinar. So I will send you our presentation, and you will check this part that was from us. And I think that we can go directly actually to the questions that our attendees are making to you. So we can start, I think, with a question to José Carlos. I think we only have time for a question for each, and not that much time, but I think we can start with José Carlos.
Can I propose something? There is the same question that Chris Holroyd placed here is the one that that I really, I don't know, maybe that Faith could answer or someone could answer, is about the difference between semi-exclusive license and non-exclusive license. I don't know if Faith or someone can answer that, because
yeah, of course,
I'm very happy
because in my knowledge, like what we use in Brazil, Faith, is like exclusive, non-exclusive, and sole license. So what's semi-license, exclusive license? That would be really interesting.
Yeah, so feel free to start with that, of course.
Okay, sorry.
Semi-exclusive license give you the ability to license, for example, going to DNA sequences, to license a sequence to more than one company. What we have experienced that we attracted different pharma companies that interested in producing the same protein, but they have different technologies. Okay, having the patient in the most important thing for us, we decided that to ensure that the patient receive a drug at the end of 6-8 years of development, the best thing to do is to ensure that all the companies have equal chance to try. Now, pharma companies, they don't like that. They like exclusivity because it gives them competitive advantage and bigger share of the market. Okay, so what we did is we defined the field of the license by the specific technology that that company is using to develop the drug. Okay, so this is why I like this model. It's very suitable for universities. Okay, it reduces the risk, because there is a risk with drug development. There is a risk that by the end of that 6 to 8 years or 10 years, maybe nothing will come out of that. Okay, so it reduces the risk. It ensures that there is something, with our focus being the patient, there is a chance for something to be developed for the patient. And if we have all the companies successful in developing a drug, at least there are different types of carriers with the same protein. So there is different type of treatments developed, and this is good in the case of polymorphism because it answers to different needs for the patients, basically, and different types of the patient. So that's what we mean by semi-exclusivity. It's just an example that legally we define exclusivity by field only. Does that answer your question?
Yeah, can I say something? Really nice. Also, we use the same strategy in Brazil, which is concerning like license taking into consideration the field of use. So I dealt with at the State University of Rio de Janeiro with I'm gonna give a general example. We have a chemical called fipronil. I don't know how to say that in English. Really, I think maybe it is the same. That applies, but the point is that this chemical compound applies to human medicines, for example, veterinary and agriculture. So they have 3 fields of use. So all of them, they are biotech, but one is for humans, animals, agriculture. So for different, for a specific field of use, we selected different with different licensee. So it worked really well. So I think it's more or less the same that you are talking about.
Okay. Sorry, what Faith?
Yeah, I just want to. It is Chris Holroyd that asked the question about semi-exclusivity. I just want to confirm whether my answer did explain it to you. If you want, you can communicate with me separately if you have more questions.
Of course, we will send not only the presentation but also all your contacts. So if people want to ask you or any of us any specific question, okay, they can do it. I would say that we only have time for one more question because we are clearly past our time. So I would ask this question to Wazyu. And I would say that an interesting question that we have for Wazyu here is what barriers, how does successful international collaboration or lack thereof affect these technology transfer efforts?
Oh, okay. No, thanks, Andre. Yeah, I think to a significant extent, nation states or even South Africa, not just cities now, cannot work in silos. And say, for example, in clinical trials, let's say we've successfully identified targets, we have the expression systems, which is doing well. When you're going into animal studies or you're going into clinical trials, it requires huge amount of funding and also infrastructures or resources that otherwise not be available here. So in those instances, we rely heavily on international partnerships, international collaborators. It could be academics from other research institutes as well, or it could be corporates or companies that are working in that field. So for successful commercialization, irrespective of the field, now it's not just a matter of commercializing, but also for product development, for tech development, further optimizing the product itself before it reaches the market. It's very, very important. These partnerships are very, very key, whether in Europe or in the US. We as UCT, we know the value in that, not just to the funders. And yeah, not until when we are properly positioned, and we have those networks that we're actually then able to, successfully move a volume of this product or of these inventions or technologies to reach their actual impact, to make the actual socioeconomic impact and reach the markets as soon as possible. So yeah, it has a huge impact on what we do, and we rely heavily on international collaboration. And yeah, it's really important for the successes of commercializing our technologies to have those partnerships.
Thank you so much, Wazio. I think that we should stop here. I think this subject is so interesting that we could talk 1 or 2 hours, even more than about this, because I think we have a lot of questions here that I could make you. But what I suggest is that I will send the presentation to all of our attendees and all the people that registered and couldn't attend. So with our presentation, all of the contacts of Faye, Jose, Wazio will be there. So feel free to contact them with your questions. There were some questions here that we didn't have time to answer. I apologize for that, but we will answer by email, and you feel free to contact us anytime. And thank all of you, thank to our attendees, and thanks especially to all the 3 speakers. I think you gave us 3 great presentations, and I think we all learned a lot with you. Thank you so much.
Thanks, everyone.
Bye-bye.
Bye.
Bye, thank you.